as Rod said, I'll be talking about cycling accidents on rural roads and a wee bit about group riding and also incidents which occur on cycle paths. But if you haven't joined one of these webinars before, I should really explain a little bit about our firm. Now, Cycle Law Scotland, we're 10 years old this year, so we've been going a wee while now. And effectively, our aim is to provide an innovative legal service focused on providing cyclists with unparalleled legal representation following a cycling incident. So what we're all about is we are cyclists, but we're solicitors first and foremost. So we are just like you. Myself and my colleagues all ride bikes. We walk the walk, we talk the talk. We've got offices across the length and breadth of Scotland, so we're able to serve clients all over Scotland. And we often take part in lots of different events in order to promote both cycling generally, but also the firm. So you can see up there on the slide, there's Rod and Brenda on the now infamous Cycle Law Scotland tandem. If Rod had £1 for every time someone said Brenda wasn't pedalling, he'd be a rich man and we wouldn't be doing this webinar, I can assure you. The other ones up there you can see are us when we did an event helping to support Doddy, and also you can see Brenda bottom right there with our fabulous typist Marnie. They often head out together during the weekends. Now, a little bit about me, I suppose, as well, for those of you who don't know me. As I said, my name is Thomas. I'm a solicitor here at Cycle Law Scotland. I am also obviously a cyclist. Now, I come from a mountain biking background, which probably explains that picture on the left, which is my version of road biking, if you like. That was at the Etap Loch Ness, and I had to do something to try and pass the time going up the climb because I certainly wasn't the fastest going up it. So I thought I'd look the coolest doing it. Now, the reason why I decided to join Cycle Law Scotland was, as I say, first and foremost, I have a big background in cycling. I've always ridden bikes since I was a kid. It's my first love, and it's something that I've always really enjoyed doing, both with friends and by myself. And when it came time to choose what I wanted to do in life, I thought a law degree sounded like, you know, a good idea. It's a sturdy profession. So I went away off to Aberdeen to do that. Then I came back to Edinburgh and was lucky enough to be offered a job at Cycle Law Scotland. And I've been a solicitor qualified here for almost 2 years now. So it's great to be able to combine both my love for cycling, but also able to support clients as a result of obviously having learned the legal skills I have. But I'm able to appreciate the perspectives that cyclists have because I am one. Now, just a little bit of groundwork before we get going with some of these case law and case studies. It's important to kind of try and understand the framework within which a civil claim operates. Now, without boring the pants off of all of you by commencing a first year delict course, this is just a little kind of sprinkling as to kind of the framework that a case may operate in. So broadly speaking, there are two branches to Scots law. One is the civil law and the other is the criminal law, both separate and distinct from each other. Now, the way in which they're separate and distinct is two. Number one is the parties involved, and number two is the burden of proof. So parties involved in a criminal action are the state and an accused individual, whereas in the civil law, that operates a law between private individuals. So when you have a contractual dispute or, for example, a personal injury action, you have somebody who's been harmed as a result of the actions of somebody else, two private individuals. Now, the burden of proof is lower in the civil courts. The criminal law requires somebody to prove something beyond a reasonable doubt. And those of you who are old enough to remember Rumpel of the Old Bailey will remember that that was something he took great pleasure in dismantling from a lot of prosecution cases, seeping in that reasonable doubt to the minds of the jury. With civil law, what you're looking at is on balance of probabilities. So is something more likely than not? You effectively are able to say that on a 50-50 scale, if something is 51% more likely to have happened, then you can progress with a claim if you like. That's what you're really looking at. It's that much lower burden of proof that you have to get over. But equally, it's the harmed person that needs to bring the action. So if you're a cyclist injured as a result of somebody else's fault, if you like, you still have to obviously bring the action. So this lower burden of proof almost compensates for that, but it is you bringing the action. A lot of European countries flip this on its head, where the driver has to prove they hadn't been negligent. But here we still have that the party that was harmed has to bring the action. So the way in which you're kind of assessing these things is on what's known as the duty of care. So when you have, the law governing private individual relationships, you need a stick by which to measure how a wrong would be measured, really. So we do that with duty of care, and it's effectively a legal obligation imposed on individuals, requiring them to adhere to a certain reasonable standard of care while performing acts that could foreseeably harm others, such as driving a car or riding a bicycle if you're riding along a shared path, for example. So you as a road user, whether you be cyclist, driver, horse rider, pedestrian, anything in between, you have a duty to take reasonable care to avoid doing or omitting to do something which might harm another person. So effectively, you're required to drive to a reasonable standard or ride to a reasonable standard and operate reasonable skill and care. Now, that is obviously a subjective standard. What is reasonable? Now, the law has ways in which we measure what is reasonable. When I was learning all about this back up in Aberdeen, the standard was the man on the Clapham omnibus. That was the phrase used, and it's the hypothetical ordinary and reasonable person was the man on the Clapham omnibus. So that was the way in which the reasonable person was measured back then. I think there is a more updated one now, but you can imagine what a reasonable person may be. That's effectively what we're looking at. That's the standard and the duty of care owed by individuals to other individuals. Now, one of the key documents, the Bible, if you like, is the Highway Code. If you have a question about how to ride your bicycle on the road, it's probably in here. Now, we're supposed to know the Highway Code if we're going out on the road, but I don't know it off by heart, and I expect you don't know it off by heart either. None of us know it off by heart unless we are particularly interested. I wasn't going to use the word sad because I thought perhaps somebody out there might have memorized it, so I don't want to do you down for what you have achieved. Rules for cyclists are found in sections 59 to 82. It covers all sorts, from how to actually ride on the roads, to the clothing you should wear, to how your bike should even be prepared. One of the common questions I saw, and it was in the comments about this webinar, was whether or not bells are required. Now, bells are not a legal requirement for bikes using the road. Highway Code does not stipulate that a bell must be used. You can shout, hello, I'm behind you. But it's one of those things which people tend to get a little bit riled up about, particularly on a shared use path. How do you approach a pedestrian from behind who doesn't know you're there? Ultimately, really, when we're looking at these things, all the Highway Code is it's an amalgamation of what should be common sense. But nowadays, common sense is becoming a lot less common. So it's important to remember that if you are stuck and if you do ever have questions, it's probably in that little book. So a lot of the common cycling incidents we see, and you can imagine these are like the highlights really of the year, if you like. Dooring cases are very common. Roundabouts, close passes, junctions, all of these places are effectively areas where cyclists can't be seen at times. It often comes down to people not seeing the smaller, more vulnerable road user. So it's always a good idea to give way to anything larger than you. The ones that are slightly less common are ones where people may be hit from behind, group riding, and cycle paths. We don't see too many of these types of incidences, and I don't know why that is. It's just, I believe the ones that are more common are just more common by virtue of more people probably riding on the roads as an individual commuting. And also cyclepaths, your speeds tend to be lower and you've got less dangers really from, all your dangers are going to be as either a dog, another person, or another cyclist really. So These are the more rare ones, and that's really what my talk tonight is going to cover. And to do that, we'll be looking at 3 different cases which have been heard in a court, and 3 which did not make it to court but were handled by the firm, and they could have gone all the way. Now, this first one is a very interesting case involving a dog, believe it or not. Now, the cyclist was seeking damages in respect of injuries sustained following a collision between her and a dog, which was owned by a gentleman by the name of Thomas Coope. Now, just a wee bit of background about the cyclist, Miss Sandison. She had joined a club known as the Johnston Wheelers. I don't know if we have any Johnston Wheelers members out there in the crowd tonight, but if you are, raise your hand. She was a frequent cyclist, big into it. And her and her husband would often go for a ride of around 38 to 39 miles of an evening. She was trying to train for the, I think it was the Étape Caledonia at the time. And this was the route she was taking, I believe, at the time of the incident. Now, those of you who have done the Étape will know that it's a route which takes in kind of the Trossachs and Perthshire, and it goes up to, I think it's 84 miles or roundabouts there. So I think I've done it myself. Well, I have done it myself a couple of times, just about made it. But anyway, the cyclist was cycling along with her husband at the time on this single track road, which you can see up there on the image on the bottom right there. Now, it's a public road, and therefore it was subject to normal rules of the road, which can be found in the Highway Code. But just around the corner from the road was a van which was parked, which could not be seen by the cyclists. It's parked in a blind spot in a lay-by just off to the side of the road. Now, the 2 gentlemen, or 3 gentlemen actually, who had been using the van were fishing locally down in the water, and they had some dogs with them. Now, when they parked up their van in order to get out and go fishing, they let the doors open of the van and the 2 dogs jumped out. One was a spaniel and one was a Labrador. The color of the Labrador seems to vary in the judgment from chocolate to black, and it goes back and forth between whether it was a chocolate or black Labrador. But for these purposes, we'll say it was a Labrador. Now, both the dogs just went out, and because it's a rural road, they hopped across the other side of the road and were just snuffling about, as dogs do. And round the corner come the cyclists. Now, the first cyclist managed to avoid these dogs, but when the first cyclist went past, the owner saw the cyclist had gone past and decided to call the dogs back across the road. Big mistake. As he called the dogs back across the road, the spaniel made it across, but the dozy Labrador, as Labradors do, as they plod along. I know this because I have a Labrador. As he is walking along the road, our poor unfortunate cyclist comes round the corner of a blind bend to be confronted with this dog and goes right into the dog. Now, the question was, who was responsible for the action? And it came down to effectively a case being raised against the owner of the dog in the first instance. Now, the cyclist had established negligence on the part of the dog owner. Effectively, you need to be in control of an animal. It doesn't necessarily need to be on a lead, but you need to be in control of it at all times. So by virtue of being across the other side of the road, the dog was not really under the full control of the defender in this particular case. So the cyclist was successful in establishing liability, but equally, in the judgment, it was recognized that there's not an absolute duty to guard against all potential hazards. So there was evidence that the cyclist had been, cracking on a little bit. And she herself also had a responsibility to take reasonable care for her own safety and avoiding any potential hazards that might have been around that blind bend. A little bit harsh on one view, because you might not necessarily expect a Labrador to be plodding along round a blind bend, but nonetheless, that was the decision. So the accident didn't happen by virtue of the owner of the dog's sole conduct. It was contributed in some way to by the cyclist herself in the way that she was riding, because there was evidence that she had been riding at a fairly high speed. So there was a contributory negligence finding of 30% in this particular case against the cyclist. So she was only able to recover 70% of her damages, which is still a significant proportion. When you look at things in the round and the findings and fact of this particular case, it's probably quite a fair decision. But nonetheless, there have been some commentators that have said that that's quite a harsh thing to impose on the cyclist, particularly as it might not have necessarily been reasonably foreseeable that there would be a dog around that corner. But just something to bear in mind. Now, the next case was one that did also proceed to a full, what they're known as a civil proof, which is effectively a trial. This one was handled by Cycle Law Scotland, and it was heard in the All Scotland Personal Injury Court. Now, just a wee bit of background, the cyclist raised an action against a lorry driver in respect of injuries sustained in a collision. The value of the case was agreed, so the whole proof, the trial, was restricted just to liability, who's at fault. And it was all about a tanker which had been parked off to the left-hand side of the road, you can see here. Now on the right, there's a farm, and this particular tanker was delivering to this farm. So the cyclist involved was a highly experienced cyclist, and she had been traveling as part of a chain gang formation with 3 other experienced cyclists at approximately 25 miles per hour. Now, I think I sat in for 1 or 2 of the days of this proof, and trying to explain to an All Scotland Personal Injury Court sheriff what a chain gang was proved particularly tricky, but we got there in the end. Effectively, this group of cyclists came upon this tanker and they decided to overtake it. There was nothing coming the other way, so they pull out. And then suddenly, this tanker starts to move off. No indication, nothing. The tanker drives forward slowly in the same direction as this team of cyclists. So the first cyclist, when seeing this, takes immediate evasive action and they brake sharply. And they veer into our cycling client, Sally Nicol. So this is one cyclist taking evasive action and colliding with another. Now, the argument was that the accident was caused as a result of that cyclist's evasive action. You know, if they hadn't braked sharply and veered into Sally, the accident would have happened. That was not the view that we held, hence why this case ended up at a proof. So Sally gave evidence that, and other cyclists gave evidence that effectively the lorry was stationary at the time of the collision. So there was an argument over whether or not this lorry had actually moved. In any case, there was still put forward an argument that even if there was a finding of liability against the driver of the lorry, there still should be a finding, as in the previous case, of contributory negligence against the cyclist, Sally, because of the way in which she had been riding. Effectively, their argument was that she had breached the highway code by cycling too close to the cyclist in front of her. Not an unreasonable argument to make, but their assessment was that damages should be reduced by 75%. So you can have a situation where even if you can establish liability, there is a very real danger that your damages can be significantly reduced. So whether or not you class that as justice is, you know, up for debate. But the case was heard, and this was the judgment. Sally and her witnesses were found to be credible and reliable, which is very important when you're trying to actually pursue a case. There was a farmer who had given evidence in support of the tanker driver, and he was found not to be a reliable witness, a bit of a cycle hater. And he was effectively inconsistent in relation to the evidence that was led by the other cyclists, and he effectively was not preferred to all of the other cyclist evidence. Even though they knew each other, they were still found to be credible and reliable, which is very important from a factual point of view. So Sally had successfully, with our help, proved on balanced probabilities that the cause of the collision was suddenly that lorry driver moving without indication, moved the lorry slowly forwards from a stationary position when it was in the course of being overtaken by those cyclists, as opposed to it never moving at all. So there was no evidence led that would enable a court to draw any adverse inferences from what Sally was doing in terms of how close she was from the cyclists in front. No expert evidence, nothing at all. So it was actually a really good decision in the end of the day. Normally, these aspect decisions come down quite heavily in favor of defenders, and that's only because when you see a case that's actually gone to court, it's because a defender thinks they can win it. Otherwise, it would have been settled a long time ago. So these are quite finely balanced cases that come to court sometimes, but it's just a demonstration of the importance of getting good witness evidence and also trying to combat arguments that might come up from a defender.
Did I get 100%, Thomas?
I believe so, yes.
Okay, I think that's the correct. I just wanted to check. Okay.
Now, the last case that we're going to look at involves a 16-year-old boy who was cycling along a footpath at 8 a.m. Now, you can see up there in the diagram the kind of path he took. Not the cleverest decision. And basically, the case revolved around, again, contributory negligence of the cyclist. This case, because of the circumstances surrounding it, was one that went through a number of stages, and it ended up all the way up at the appeal court in England. And the established facts were this: that the cyclist had been cycling along a pavement when he turned onto the road and was struck by a car. Now, at his first police interview, the driver of the car estimated his speed at 35 miles per hour. The speed is quite important, so remember that. Now, at the civil trial, he said his speed was 30 miles per hour, so he knocked 5 miles per hour off for good measure. The speed limit on the road was 30 miles per hour, which is convenient. And the judge initially found that the driver of the car was liable for causing the accident, but that the cyclist had contributed by leaving the pavement in such a way to obviously make himself, put himself in a position of danger. Now, the original judge assessed contributory negligence at 50%, but found it just and equitable to reduce this by 1/3 because of the age of the cyclist, only 16, remember. The judge found that the car driver had been traveling at 35 miles per hour, and there was a lot of evidence as to the distance traveled over a time, and it was expert evidence that was able to inform a lot of these findings in fact. That you can see if you go and have a look at the judgment for yourself. We have a copy on our website if you are interested. Now, there was an appeal, but it gets quite convoluted here because there was also a cross appeal by the cyclist about the level at which contributory negligence was found. So there was an appeal by the car driver as to the finding of fault. There was also an appeal by the cyclist as to the level of contributory negligence attributed to him. Effectively, the way in which it balanced out at the end of the day was that damages should be reduced by 50% for the cyclist to reflect his contributory negligence. Getting away with pulling a move like that and only having 50% contributory negligence is quite good going, but it does show the importance that a court will put on the fact that a cyclist is a vulnerable road user. So even if you are in a situation where you are perhaps guilty of doing something which is not perhaps clever or by the book, shall we say, it doesn't necessarily preclude you from pursuing a claim for damages. So often with these things, it does come down to the individual factual circumstances, and that's what's so important. Now, moving on to some case studies. These are cases which didn't make it to court, but the firm has handled. And I'm very grateful for the people involved for actually allowing us to share these, because it's a peek behind the curtain. I've mentioned this in previous webinars I've done. You very rarely get to know, unless you go through the process yourself, how a personal injury claim actually works. And it is quite rare for a case to go to court. As I said, 90%, more than 90% of cases will settle before you get anywhere near a court or even raise a court action. And that's because at each and every turn, our judicial system is designed, particularly for personal injury, to try and encourage settlement between parties before we actually end up in front of a judge, because it's very, very, very expensive. So these case studies represent cases which didn't go to court, but possibly could. But the reason they didn't perhaps go all the way is because of the work done in securing compensation for these clients. So this case involved a lady who was a confident, experienced cyclist, and she'd actually even achieved podium places in sportives. Now, some of you out there might say that a sportive isn't a real race, but we all know that once the clock is running, it is. And she was cycling a short distance away from her work on the A87 near Kyle in the northwest of Scotland, that you can see up there in the picture. Now, she was traveling at around about 20 miles per hour on a straight and open section of road, very clear visibility and dry conditions, when a car suddenly drove into her from behind. Now, you can see in the road, there's a huge amount of sightline. How can you not see a cyclist on that road? The particular road is subject to a national speed limit. So you can imagine vehicles would travel quite quickly up and down this road. And the belief was that the driver of that Seat, which hit this lady, was traveling in excess of 50 miles per hour. So Fiona was actually wearing high vis at the time on her arms, and she had a club short sleeve jersey, which was very bright, and had a red flashing rear light. And she was positioned about 1 meter into the carriageway. So quite easily seen, one would have hoped. On the impact with the vehicle, Fiona landed on the windscreen, which you can see there in the picture. And she was then thrown onto the road as the car began to brake. She was clipped into her bike at the time, and you can see the damage sustained to the bike. Unfortunately, because she was clipped in, her bike came with her up onto the windscreen. And then once she was flung off the car bonnet, at that point, she became disengaged from her cleats, and she was effectively thrown into the roadway. Astonishingly, but very thankfully, Fiona managed to actually walk away from the incident without any serious fractures, which is quite remarkable given the speed that the third party was traveling at the time. She did sustain, though, quite extensive ligament damage to her left shoulder. She also broke her big toe and had very deep cuts, which required stitches, but she was generally battered and bruised all over, as you would be if you were hit from behind by a car. But there was obviously, as you can see in the photo, very significant damage to both her helmet and her bicycle. So Fiona got in contact with us in order to pursue a personal injury claim against the driver's insurance company. So she knew that she would require extensive physiotherapy at this stage to assist with her recovery, to get back to full fitness, because she was looking to get back on her bike as soon as possible. So we intimated the claim to the insurers at a very early stage, and liability, as you can imagine, was admitted early on. You can't really deny liability for an incident like this. Even the most brass-necked of insurers would not do that. So they made an early offer, the insurers, of £2,500 plus private physiotherapy. And this offer within 1 month of the collision. Quite a devious and underhand tactic by insurance companies. Sometimes you see this. They're known as pre-medical offers. So ordinarily what you would have is a client that goes through the whole process of recovering. And then at that stage, you can make an assessment as to the value of their claim because they've been through the process. But sometimes what an insurer will do is dangle a big carrot in front of a client's face and say, we'll give you this now if you settle. Pretty unfair tactics, and it puts a client in a bit of a difficult position because sometimes these offers are pitched as level which may even be in excess of what a client's claim is worth. But you as a solicitor cannot advise them because you don't have that evidence yet. But Fiona's the boss, so we took her instructions and she said, no, I'd like to proceed on through the process. And we were very happy that she wanted to do that. So when it came to actually settling the case, once we'd gone through the whole process of gathering the medical evidence, the insurers were unwilling to compensate Fiona for that replacement helmet you can see there in the photo. Now, we did send this image showing the damage to the helmet to the insurers, but they insisted upon an original purchase receipt, can you believe? Now, normally you don't have this argument. An insurer will always replace protective items of clothing for like basis. So you're normally always be able to recover 100% of the value of a helmet, for example. And given the extent of the collision, we were unwilling to resolve matters if the insurer wasn't going to compensate Fiona for her helmet. So in this very rare occasion, we actually raised court proceedings for the value of a helmet. An unbelievable position adopted by an insurer because raising court proceedings is always going to cost them more than just coming up to meet the £50 it would have been extra to actually compensate Fiona for her replacement helmet. And our position is this: a protective piece of equipment must be replaced in full. That's generally the position agreed upon between a lot of insurers, but every once in a while you get the chancer that says no. And on this particular occasion, that's what we had. So once the matter had actually been raised, what you get is it goes out of the hands of the insurer and into the hands of the insurer's solicitor, my opposite number, if you like. And the insurer's solicitor provides the same kind of independent and objective legal advice to the insurer that I am able to provide to my clients. So the insurer's solicitor would have taken one look at this and said, look, you better pay the cost of that helmet, otherwise it's going to cost you a lot of money. And that's exactly what happened. They eventually made a more reasonable offer, which took into consideration the cost of the helmet. And Fiona was very happy with the outcome of the claim. This case really demonstrates that obviously, whilst wearing a helmet isn't compulsory, those who choose to wear a helmet should really be fully compensated if the helmet's been damaged at all. And that in any road traffic collision, you're always looking to replace your helmet because obviously it's an item of safety. And your head's something that you want to protect. So it would never be appropriate to purchase a second-hand helmet, so it's not appropriate to not compensate in full for a helmet. The second case study we'll have a wee look at, if you're all still with me and haven't gone off to ride your bikes, is a case involving a bridge. Now, the client's name is Joe, and he came to us back in the summer of 2013. Joe was quite a keen recreational cyclist, and he fell from his bike when he crossed an old railway bridge that had been incorporated into a cycle path in the Midlothian area. Now, those of us who cycle regularly will know that often these old railway paths are converted into cycle paths, which is great, but sometimes the council and their partners cut corners a little bit when installing them. So you have situations like this, where you get a rickety old bridge. Now, the bridge deck, as you can see in the photos, is covered in wooden slats, and they had been laid parallel to the direction of travel. So as Joe cycled across this bridge, his front wheel became caught in one of the gaps between the slats, which was rather unfortunate for him. Those of you who have ever cycled in Edinburgh and gone anywhere near a tram track, this might be a familiar scenario that you might have been in yourself. Now, Joe, when he came into contact with this particular slat, was unfortunately thrown from his bicycle and he broke and dislocated his arm. So quite a serious injury. He was taken to hospital and he required surgery actually to insert plates and screws in his forearm to actually stabilize the injury. And initially, because Joe was a trade union member, he was referred directly to a general personal injury firm of solicitors to seek compensation for his injuries. And following a few, I don't want to use the word half-hearted, but I will, half-hearted investigations, this solicitor turned down Joe's case. And the basis upon which turning down the case, it was effectively that there were no reasonable prospects of success against the council who had responsibility for this path. Now, no reasonable, or we won't be able to prove your case on balance of probabilities, what I mentioned earlier. And some ways you can perhaps understand why the solicitor gave this advice, because these cases are very difficult. A council isn't expected to effectively protect everybody who uses the road network for every possible foreseeable hazard. That would just be an unbelievable burden to place them under, particularly given the funding available to them and the resources. So when you're looking at cases against a local authority, it has to be borne in mind that, you know, the deck of cards is stacked very heavily in the favor of the local authority. But Joe then came to us, and then we reviewed the previous solicitor's file, and although they had spoken with an engineer to try and get a view as to, is this bridge effectively a safe way in which to have a cycle path, and does it represent a hazard, they never actually instructed a formal report from a civil engineer. So road defect cases, as I said, are very rarely straightforward. So you really need to place emphasis on full investigations, and you need to carry those out. So you have in Scots law 3 years to actually make a claim or have your claim settled from the date it happens. So the case needs to either be raised in court or settled within that 3 years. And Joe's case was getting towards the end of that period. So initially we were quite quick in order to try and set up a file, but we had to raise an action against the local authority immediately without doing full investigations, just to protect Joe's right to claim. And the decision was made on the basis that the incident was foreseeable, given the nature of the bridge's deck structure. I mean, you take one look at that. As I said, common sense is not all that common. And you can easily see whenever that piece of wood is going to get wet, it's going to cause problems. But equally, you can see the wheel goes straight between the slats. It's there in black and white. So we made full investigations, or should I say fuller investigations than the previous solicitor did. And we instructed a full engineer's report. We also were able to uncover freedom of information documentation from the council. It's very important in these cases that you understand what the council's actual inspection regime is of these cycle paths, because that can give you a little bit of an insight as to how you might be able to mount a case against them. And rather unbelievably, what the council's document showed is that they have a reactive system of inspection in place for this path. So plainly put, they don't do anything unless there's a report of an incident or a complaint logged. They won't go along here on a regular basis and have a look at it, and they won't send an inspector along it at all unless something happens. It's not really a policy that is generally encouraged, and a court would probably frown upon a reactive policy of inspection. So even though we had all this evidence at our disposal, the council still denied liability, but that's unsurprising because council always does. And 8 months after the action was raised, we did actually get an offer from the defenders, and it was a reasonable offer to settle the case, and it was accepted. But what this case does highlight is the importance of being able to instruct your own solicitor of choice and not be pressurized into using one that's just allocated to you. Just like anybody else, a local authority owes a duty of reasonable care to all road users. And we recognize that this bridge did represent a hazard, particularly to cyclists. And interestingly, since Joe's incident was reported to the council, this is what the bridge now looks like. They made a temporary repair that you saw in the previous slide, but eventually they opted to redeck the whole bridge. And as you can see, those slats are horizontal, not vertically placed. So small victories. Every now and then you do get a little bit of a smile because your case has actually contributed to some wider good, even though liability was never admitted. But there we go, other cyclists protected. Thank you to that local authority. The last case study, which I'll have a wee chat about, is one that I've just recently settled, and it involves a Tesco delivery van. It demonstrates rural roads really quite well. This particular road, for those of you who are borders based, is the back road that runs parallel to the A72 Peebles to Clovenfords Road. It's unnamed, it has passing places, it has wonderful wildlife, it has ginormous potholes. You know the type of rural road I'm talking about. And the gentleman whom we represented was riding effectively what would be towards us in this picture. And he was riding with a friend, and they were riding two abreast, which you can do. The highway code says as much, but the highway code does also recommend that when you're on narrow, twisty roads to ride in single file to allow cars to pass. But there was nobody immediately behind my client, so as he came around a corner and was proceeding downhill, coming up the other way of the hill was a Tesco delivery van. Now, there are some houses along this route, but I have no idea why the Tesco delivery van was actually on this particular road, because what we were able to uncover from the delivery route was he didn't actually have any deliveries to make along this road. So whether he was driving it for a jolly or who knows. Long and short of it is that as my poor client comes round the corner, he's confronted with this van. And this van doesn't yield from its path at all, doesn't slow down, it was as though he doesn't even see the cyclist and his friend. So he takes evasive action. He rides across the face of his friend to the left in order to avoid a head-on collision. And unfortunately, he lost his control of his bicycle in the gravel, which you can see just off to the right. Suffered quite nasty deglovering injuries to his hands. And the Tesco van drives off. Doesn't stop, never stopped. So we were able to actually eventually trace the Tesco van, because obviously by virtue of it being a Tesco van, it's ginormous and blue. So we were able to actually intimate a claim to Tesco. And because we had the rough time of the incident and the actual locus, Tesco were able to confirm the vehicle itself. Now, very helpfully, what Tesco do is they have GPS trackers on all of their vans. So when we initially intimated our claim, liability was denied by Tesco's lawyers. And the reason they denied liability was this GPS tracking information. They provided a very helpful spreadsheet of all of that information. But contained within that spreadsheet of information was the speed that the Tesco van was driving, the time at which it was driving those speeds, GPS coordinates of where the van was positioned, and very helpfully, it also made some comments on the driving of the driver every now and then. So I don't know the actual name of this GPS system, but the AI, whatever is controlling it, sometimes says things like harsh cornering, harsh acceleration, excessive braking. You get the picture. So I'm not sure whether or not the lawyers for Tesco had actually reviewed the spreadsheet in detail, because when it was sent to me, alarm bells began to ring, because I looked through it and approximately at the time of the incident, you had both harsh cornering and excessive acceleration. The harsh cornering appeared to be immediately before the corner which the Tesco van drove up to drive up the hill. And the harsh acceleration appeared to be at the time at which the incident happened. So from my point of view, and I advised this to the client, that liability clearly rested with the driver of the Tesco van. And by extension, because he's an employee of Tesco's, Tesco ultimately have to bear responsibility under something known as vicarious liability. Because number one, if the driver had seen the cyclists and failed to do anything to alter his course, that in itself could be seen as negligent. Because if you have two cyclists coming towards you, common sense dictates that you should really slow down or alter your course in some way, particularly if the road's narrow. You don't just plow on through. Secondly, even if he hadn't seen the cyclists, driving off, knowing a collision had occurred, is not something which is generally accepted as being allowed to do. It's also illegal. But the driver's story was effectively that he was unaware of an incident occurring. So the conclusion there had to be that, well, he simply failed to see my client and his friend as they're cycling along. So that in itself represents negligence because you failed to observe another road user. So because of the GPS evidence we had, and also a very helpful witness statement from the cyclist's friend as to the incident circumstances, even though this case was raised in court and made it all the way to what's known as a pre-trial meeting, it was actually settled at the pre-trial meeting once I'd walked the solicitor for Tesco through what the GPS footage actually showed. And at that stage, a decent offer was made and was duly accepted by the client. So it was a good outcome there. But again, it demonstrates just the need to actually really take a deep dive into all of the information available to you and go through everything nut and bolt, because as I say, each case is dependent on factual circumstances. So really behind all of this and why we do this work is to restore people to the position they were but for the accident. That's really what civil law is designed to do, particularly for personal injury actions. The Latin maxim is restitutio ad integrum, which roughly translated means restoring an injured party to the situation which would have prevailed had no injury been sustained. All very lofty ideals. The fiction is that you're trying to put a person back into the position they were before the accident. Now, I say a fiction because no amount of compensation ever takes back what has happened to you if you're involved in a cycling incident. Any client I've ever encountered, and you will sometimes see reports in the media of what's known as a compensation culture. I can assure you a compensation culture does not exist in Scotland. Any client I've ever had would much rather their accident never, ever have occurred than be paid compensation. It's not something which you get because you've won something. Compensation is to recognize that a harm has been perpetrated on you. And it's the only way and the only measure by which our society has to try and put right that harm. So you've not won anything. It's simply to try and put you back into that position you were but for the accident. And in some cases, it can be very important because it pays for things like care and assistance, and it can have an impact on the rest of the life of the person as a result of a particularly bad accident. So that should be borne in mind, and that's why we do what we do. But should it happen to you, what should you do? Now, normally, if you're involved in a cycling accident, you might be in the back of an ambulance, so you can't necessarily take all the information in that you'd like to. That's where Police Scotland play a role. If the police attend upon an incident, they have, first of all, to preserve life, but thereafter, they're quite interested in gathering information. So normally, if you're unable to take down information yourself, the Police Scotland will be able to take that information and then provide it to you or your solicitor at a later stage. But if you are in a position to get information at the scene, do take pictures. Pictures are really helpful. We've all got phones at our disposal now. I noticed just before we got going, there was a question about helmet cameras. Brilliant things. Helmet cameras, if you want to use them, are fabulous because there's no talking around the evidence that a video shows. Sometimes you can have situations where you're involved in, it might be a little bit of an innocuous accident. Liability will be very straightforward, and the driver of the vehicle is very apologetic at the scene. But once you contact a solicitor and you intimate a claim, suddenly that driver's story changes. You're faced with an uphill battle trying to prove, obviously, because you're the injured party, you have to prove that the accident was caused as a result of the negligence of somebody else. Then you're faced with having to do this whole process of gathering all the evidence. So if it does happen to you, it's important to get as much information as you can if you're able to get it. We are available. If you ever want any free advice, the telephone number is there. You can also find it on our website. We also have social media channels, which are very well operated by Rod and his team. So if there are ever any questions or you ever wish to offer your opinion on anything we post, please do. We always like to hear from you. And if you need advice, we are here for you. There's no obligation, and we're cyclists just like you, so happy to chat. Now, I think that's me. I think I've taken up far too much of all your evenings. If there are any questions, do let me know. But if you have places to go, then if you want to send in a question or put a comment in, we can get back to you at a later stage. But for now, that's me. Thank you very much, everybody, for listening.
Brilliant, Thomas. Thank you very much once again for that. That was extremely enlightening and really interesting, particularly some of those cases I hadn't heard before. Brilliant. Thank you very much indeed. Whilst you've been talking, yes, you picked up the question about helmet cams or head cams, which you've dealt with. I noticed there was a couple of other questions that came in. Andrea actually questioned whether dogs must actually be on a lead in order to consider them to be under control. So she's questioning whether it's okay for them just to be trotting along, even if they're well behaved. Is that considered to be under control, or must they be on a lead?
So under control doesn't necessarily follow that a dog has to be on a lead to be considered under control. If you've ever seen any dog trialing events or anything like that, the dogs are very clearly under control, even though they're not on a lead. If you were to take the step to say that a dog is only under control when on a lead, you're effectively condemning, say, a Labrador running freely in a field to be a dangerous activity, which it isn't. So the thing which the courts often have to balance is known as the floodgate argument, as to whether or not finding something as being negligent opens the floodgates to all of these claims coming through. And that's a policy decision which is often made. But the long and short of it is no, a dog does not have to be on a lead to be considered under control. It will come down to the factual circumstances of the accident.
Okay, thank you for that. Andrew's asked the question in relation to liability. I think it's actually in relation to the road share campaign, which perhaps he's not aware of. So he's asking why the UK doesn't have the same kind of liability laws as they do in Holland and elsewhere in Europe, in fact, nearly everywhere in Europe, apart from some small locations. Could this be introduced by stealth through campaign lobbying to emphasise duty of care to drivers? Maybe I should answer that rather than you, but no.
Well, it sounds like an excellent idea and something we are actually very actively involved in doing. As for the reasons why we don't do it and our European neighbours do, it comes from a long line of, it goes all the way back to when the motor vehicle was actually invented and introduced. And I know this because I did my dissertation on this particular topic. And what I found was when the motor vehicle was introduced, there was this big argument over whether or not it was a dangerous object. Was it something which strict liability should apply to in order to recognize the harm that it could bring to a potential incident? So if you're operating this, what's effectively a dangerous piece of machinery, you have to have placed upon you quite a heavy burden because you are operating that dangerous piece of machinery. And the law came to a juncture as to whether or not a motor vehicle would be considered something which was effectively dangerous to warrant strict liability. And we went one way and our European neighbours went the other. From what I found, the reasons for this weren't entirely clear, but it appeared as though many members of the judiciary were, of course, members of the upper class, and they drove motor vehicles, the early ones. And they didn't want to find their new toys to be dangerous weapons, effectively. So that's why the law developed that way. There have been in the past lots of comments and a lot of quite enlightened judicial thinking about the particular topic, but it takes really legislation now at this stage. The common law is judge-made law, but you really need legislation in order to have something like that, in order to flip what our civil tradition is on its head.
Okay,
we are where we are.
Thank you for that. Andrew, can I suggest you go to roadshare.co.uk? That's the website which underpins the campaign for presumed liability in Scotland, and on there you can nip to the changes.org and stick your name on there, along with 12,500 other people who believe that should be the case. We are still working away on this. We're not quite there yet. Hopefully one day we will get there. Okay, Kirsty, you asked the question as to whether or not this has been recorded. The answer is it is. You will find this recording of this on our website, on our YouTube channel, and on social media probably first thing tomorrow morning. So our website, there's a section under CLS Web in our series. You'll find it there. So yes, and Fiona has asked a question: what if the person responsible is a pedestrian or another cyclist, and you cannot take a photograph through fear of retaliation? Should we have insurance? The old insurance question, Thomas.
Yes, a very good question. Effectively, it's quite easy in road traffic accidents because you know that a driver of a vehicle is always going to have insurance unless you're unfortunately hit by an uninsured driver, but there are provisions to make a claim even in light of that. As you say, the difficulty is a lot of pedestrians don't have insurance. Why would they? But there are ways and means depending on, again, the factual circumstances of the claim. If a pedestrian has, if they have basically home contents cover, if there's a public liability section that covers them for causing harm to individuals out with their home, then you can make a claim that way. Also, you can actually claim directly against individuals. It's not necessarily often recommended. I have had cases in the past, and it has been quite unfortunate, where you have, say, a cyclist v cyclist, where one cyclist's negligence has led to the harm and injuries sustained to the other, and that cyclist doesn't have insurance in order to cover the significant costs of damages or harm done to the other one. So you're having to advise a client that it might not necessarily be in their best interests to raise an action because they're never going to get anywhere. But there are ways and means. It is always open to you to raise an action personally against another individual, but it's something that has to be borne in mind whether or not the other individual could actually satisfy any decree against them.
Brilliant. Thank you very much, Nicol. That answers your question, Fiona. Okay, I don't think there's any other questions, Thomas, so all it leaves me to do is to thank you very much for your time, to thank everybody who joined us on the webinar this evening. I hope you enjoyed it, found it useful and informative. That's be the case in terms of the feedback we get, and even tonight various people have thanked us for, or thanked you, particularly Thomas, for a very clear presentation. Next week we have a discussion. What is next week? Next week's a discussion on cycling injuries, the types of injuries that we deal with, how they've been caused, how we deal with those, how we value those in an overall claim, and Zara will be taking you through that. So if you're interested in that, sign up, register for next week, and we will see you then. Good night.
Thanks, everybody.